If you've ever encountered someone else who is using a domain name that contains one of your trademarks or something confusingly similar to one of your trademarks, then you have what may be called a domain name dispute. Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to provide an introduction to domain name disputes by explaining important aspects of the domain name system, how trademark law applies to domain names, what a cybersquatter is, and how disputes can be resolved through a relatively quick and inexpensive legal process. If you or your company does any business online, I think you'll find this information important to protect and defend your brand in cyberspace. Domain name disputes can arise for any number of reasons, but most commonly because you or your company own a popular brand, even if it is in a small industry that someone else is trying to capitalize on. But domain name disputes can also arise if you simply fail to renew a domain name that has now been picked up by someone else, if you lost your domain name as the result of some type of fraud, or if you've ended a business relationship with a former partner who has kept the domain name for itself. I've seen it happen plenty of times. Of course, a domain name dispute can cause all sorts of problems, and fortunately, there are a number of ways they can be resolved. But before we talk about the different types of disputes and how they can be resolved, the first and most important thing to understand is simply, what is a domain name? And this may sound like a silly or very basic question, but when I began practicing law in the mid-1990s, relatively few people knew what a domain name was. And when the first disputes arose, lawyers actually had to explain to the courts and to judges what the internet was, what a domain name was, and why any of this even mattered, including whether trademark laws applied online. Today, of course, most of us know, or we think we know, what a domain name is, because we're using them every day when we type an email address or a website address. And we see domain names all around us on TV commercials and newspaper ads, on billboards and podcasts and so forth. But just to be perfectly clear, a domain name, as most of us refer to it, consists of at least two parts. The first part of a domain name is what is often referred to as the top-level domain, or TLD. This is the portion of a domain name to the right of the dot. So, for example, in the domain name CNN.com, .com is the top-level domain. And the portion to the left of the dot, in this case CNN, that's what's commonly called the second-level domain. Now, there are a finite number of top-level domains, but there are millions, literally millions of second-level domains, about 360 million actually, as of this recording. .com is certainly the most popular top-level domain, accounting for about 40% of all TLDs. But other well-known TLDs that you may have heard of include .net, .org, .edu, .gov, and in recent years, ICANN, which is the Internet Corporation for Assigned Names and Numbers. And that's a nonprofit entity that manages the global domain name system. ICANN has greatly expanded the number of top-level domain names to well over 1,000. And they now include such things as .AAA, .London, .pizza, .xyz, .site, even of course .law, and many others. Now, these types of top-level domains are often referred to as gTLDs. That is global or generic top-level domains. But there's another category of top-level domains called ccTLDs, or country code top-level domains. Every country has its own two-letter ccTLD, such as .US for the United States, .UK for the United Kingdom, .AU for Australia, .MA for Morocco, and so forth. Now, creating a new top-level domain is a complicated and very expensive process that's not always even an option. But registering a second-level domain within most of the top-level domains, again, the CNN portion, for example, of CNN.com, that's usually a very easy and inexpensive process. Indeed, in many of the top-level domain names, such as .com, anyone can register just about any second-level domain on a first-come, first-served basis, regardless of whether somebody else may have relevant trademark rights. And that's where domain name disputes arise. In fact, there's a name for many of the people who register domain names that contain or are confusingly similar to someone else's trademarks. And that name is cybersquatter. In general, cybersquatting refers to the practice of registering domain names that contain or are confusingly similar to someone else's trademark, and then using those domain names in bad faith. Now, bad faith can refer to many different types of activities. For example, some cybersquatters register a domain name and then create a website where they sell counterfeit versions of your product. Other cybersquatters may simply redirect the domain name to a website where competing goods or services are sold. Some cybersquatters may use a domain name to engage in phishing activities, which is where they send out emails that appear to be coming from you or your company, usually to trick recipients into providing personally identifiable or financial information. And in the past, many cybersquatters used domain names in connection with websites that provided pornographic content, which was a very profitable business. Now today, probably one of the most common types of cybersquatting activity simply involves using a domain name in connection with a parked web page that contains a list of links for goods or services that are related to a trademark owner, but the links are actually advertisements that generate revenue for the cybersquatter and usually send internet users away from your website and to your competitors. Some cybersquatters even use their domain names to spread viruses or malware to unsuspecting internet users. So it's easy to see why any of these types of cybersquatting activities might be problematic. These types of domain name disputes can cause you or your company to lose business, and they will often frustrate your customers or clients, who might blame you for their troubles, even if you are not responsible. Now, fortunately, there are a number of options to resolve these types of domain name disputes, the most popular of which is known as the UDRP, or the Uniform Domain Name Dispute Resolution Policy. This is an arbitration type of process that was created by ICANN in 1999. The UDRP and other domain name dispute policies that may be similar to it provide a quicker and less expensive alternative to litigation, and they are the most common way of resolving domain name disputes because they are incredibly effective for trademark owners. But it's very important to understand that not every type of domain name dispute gives rise to a legal cause of action. So a very important first step when approaching any domain name dispute is simply evaluating whether the law even provides a remedy. If the UDRP or other available legal tools are not appropriate for resolving a particular domain name dispute, it's essential to know that up front for many reasons, including to save time, to save money, and of course to avoid the inappropriateness of pursuing a domain name registrant who may have the right to use his or her domain name. Now, in my legal practice, I spend a lot of time simply evaluating domain name disputes for my clients, and I advise them about the best approach to resolve their disputes. Often this type of evaluation is relatively quick and inexpensive, and it really is the first step in understanding how to approach any domain name dispute. To learn more about domain name dispute, including details about what is required to file and win a UDRP complaint, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in internet law. Thank you.